Hello, everyone. You are joining Crypto Law Live Tuesday, May 21st. I'm James Murphy. You may know me as Meta Lawman, and we're going to talk about legal issues in crypto. And we're very, very fortunate today to have one of the smartest minds in blockchain law out there. We've got JW Verret, and let me just tell you a little bit about him. He's got 2 degrees from Harvard Law School, a JD law degree, as well as a degree from the Kennedy School of Government. He's a professor at the Antonin Scalia Law School, a terrific law school here in the Commonwealth of Virginia. And he has served on advisory committees to the SEC. He served as a chairman of a credit rating agency as well. And in his spare time, he runs a forensic accounting expert witness company, as well as everything else going on in his life. And we're very fortunate to have JW Verret on with us. JW, thanks so much for being on.
Hey, thanks, James. Good to meet you. And I've been following Meta Lawman, and I'm glad you're here taking over this show from the great John Deaton. Today I'm wearing the Deaton uniform, the jacket with the dark shirt in his honor. So we're hopeful Deaton will make it all the way into the Senate. So
yes, we are. And speaking of Deaton, let's kick things off with a discussion of course, the Ripple case, the all important Ripple case that is coming near its end, at least in the trial court, in the U.S. District Court. What are you thinking, JW, in terms of this very last but extremely important part, which is what are the remedies that are likely to be awarded against Ripple and in favor of the SEC? How are you looking at that?
Well, we're seeing the SEC acting like a bully, and this is not unusual. There have been a number of cases where the Supreme Court has come down on the SEC's abuse of disgorgement. Profits, limited to the ability to disgorge net profits, which significantly limits their power. And yet they still ask for outsized awards well beyond the scope of what they're allowed to get from SCOTUS. Why? I don't know, because they consider it a negotiation with the judge. But hopefully at some point a judge will, and I think maybe in this case a judge will, because the judge held for Ripple in most of the substantial allegations. I think a judge will look at it and say, that is so extraordinary as to be incredible. You're asking for $2 billion in disgorgement in a case where there's no actual fraud, and a $2 billion award, that was raised. I have a lot of boys who play baseball, and when you whine to the umpire after you lose, it never goes well. And I think that's what we're seeing from the SEC, to be honest.
Yeah, I think you're right. This is really an unusual case when you think about what has been invested in it in terms of the resources of the SEC, of course, the enormous financial hit to Ripple just paying their own lawyers, and then the judge and the magistrate judge who's had so much to deal with, and that massive summary judgment, cross motions. I think it may come as a surprise that there are no victims with losses in this case. That was a surprise, and the rule is in this, at least as the way the Second Circuit has interpreted the direction from the Supreme Court, that unless you have victims with pecuniary loss, you don't get any disgorgement. And so that means, I think, love to get your take, that the judge is pretty much on her own with respect to the penalty. Because, in many cases, it's pretty simple that you have some sort of disgorgement, and then the penalty is called either a one-time or a two-time, where a one-time means the same penalty amount as disgorgement, to create a disincentive for people to violate the securities laws, because you don't want a situation where all you have to do is return the money from a securities law violation. There should be a penalty. But here, I think there's a very good argument there shouldn't be any disgorgement. And so the judge is kind of on her own in fashioning a penalty in an unusual scenario. What do you think about that?
Yeah, I hope that there's no disgorgement awarded. I think that would be appropriate, because there are two stages to measuring disgorgement. The first stage is identify the illicit proceeds of a fraudulent action. And then the second stage of the disgorgement, the illicit proceeds. And then the second stage is deduct the expenses, the legitimate expenses of the company from that disgorgement award. Both stages, I think the SEC is wrong. And just to take one small example where this case could be groundbreaking, I think you can deduct all the legal expenses, even if there is a disgorgement awarded, which there shouldn't be. I think you could deduct the hundreds of millions in legal expenses, the other expenses that Ripple and the Garlinghouse have expended in developing this network. So yeah, I'm hopeful. We've gotten precedent already from this company's investment in their defense. Good precedent for the crypto world. We might get some good precedent to limit the SEC's abuse of the disgorgement remedy generally as well. So that it's an expensive payoff, but I think that's probably a payoff we're going to see out of this case.
The very last part, and we always say, well, we're at the end here, and the investors in XRP are paying such close attention to what's going on. Like, when in the world is this going to be over with? The last little flurry here at the end were some papers about redaction of information that Ripple, the company, didn't want revealed in the filings about financial matters and discounts given to institutional investors on sales of XRP. Do you have any thoughts on where that might come out?
I'm not sure, and to be honest, I haven't followed that part of it very closely. But given that this is again a company that didn't do anything wrong, this is an unusual case of the SEC investing so much time and effort in a non-registration only case where there's been no fraud. I don't know why you wouldn't give Ripple the benefit of the doubt in those kinds of redactions.
It's interesting. These redaction contests are a little bit predictable. So what has happened over the course of the case is the SEC has demanded extensive redactions when we were talking about SEC documents, Hinman emails, and related documents. There's that fight about that, and now the shoe's on the other foot, and the SEC takes the position, the public really has a right to know all this information, and redaction would be completely inappropriate here. Whereas Ripple says, you know what, we're trying to run a business here, and we're a private company. And so, yeah, I mean, however that comes out does not really influence the outcome of the case at all, but it is a typical kind of back and forth. JW, one of the things the people out there paying attention to this case always ask me is, when is this going to be over? So do you have any thoughts? It's fully submitted on this question of damages, which in my view is far, far, far simpler than massive, summary judgment cross motions with, thousands and thousands of pages. This is pretty much a legal issue. How are you thinking about when people should expect to hear from Judge Torres on the remedies?
It seems like we're close to the end of the district case. We're not. This is only the. This is only the beginning of the end. This is the end of the beginning, because we got to go to the appeals court, and then we got to go to the Supreme Court, I think, ultimately for resolution of the questions here.
That's what I've thought. That's what I've assumed as well, unless the last couple of days are signaling a real change. in the political considerations around all of this. I have assumed that this one would go to the U.S. Supreme Court. So we'll see. In terms of timing, we get this in private. I'm retired now, but in private practice, we always get the same two questions. How's the judge going to rule and when? And the answer is, I don't know the answer to either one. And then the client will say, but remember at the hearing, the judge said something that was, favorable to our side. I said, he or she may just be playing, and eliciting responses from counsel, and you can't take it to the bank, even trying to read those tea leaves. But in any event, I feel like, there is a rhythm in the federal courts to service of clerks and clerkships in federal court. And these clerkships come to an end around the end of August. And so for that reason, I think the judge and the clerks might be inclined to not hand this over to a new set of clerks coming in around Labor Day. And so I think it's likely that we'll get a decision in July or August. But then again, some judges take a lot of vacation, in those 2 months. So you never know. But it would not surprise me if it comes out prior to Labor Day. But we'll see. So anyway, let's pull back a little bit and take a broader view of what's going on with the SEC. And I know that you followed things very carefully, and you've recently published a piece talking about this effort by the SEC, and you've described it as enforcement by destruction, or regulation by destruction. Can you share with us kind of how you are thinking about this big picture and what we're seeing from the SEC with respect to these crypto issues?
Yeah, historically, the SEC's approach to new innovations in finance and the way money moves has been to adapt and adjust. They did this with asset-backed securities. They created a whole regulatory regime for asset-backed securities that was tailored to how those securities were designed, most of which weren't the kind of asset-backed securities of from the financial crisis, most of which were consumer finance to help money flow to automobile financing. So they adapted the regime. They had all sorts of really thoughtful, curious questions in their rule proposal on asset-backed securities, like, we understand that these are not owned by a board of directors or a CEO, so traditional disclosures wouldn't work. What sort of other disclosures should we utilize? And yet when it comes to crypto, they've done the opposite. And they've said, you know what, just come in and register, just comply. By the way, we know you can't really comply. And we're going to sue as many actors as we can in this space and just shut them down.
Yeah, I experienced, my clients experienced that. And your phrase is better, but to me, the process is the punishment. So many clients who are regulated in a sense by the SEC, if they're public companies, whether they're financial firms or not, whether they're banks, broker dealers, but if they're public companies, you must deal with the SEC all the time. The Division of Corporate Finance, you're always in contact with them, your 10Qs, et cetera, your reporting obligations. And therefore, there is this sense of, boy, you really don't want to piss them off. So, do we want to spend the shareholders' money on defending this thing where we think we're right and they're wrong? A lot of that calculation leads to settlements, unfortunately. And here, when you're talking so much about innovation, it's really tragic, because before I retired, we had clients where we would tell them, this is the existing regulatory atmosphere and environment. If you want to do anything touching upon crypto, this is what it looks like, and these are the uncertainties. And we had a number of clients say, thanks very much for that information. We're leaving and heading out to Estonia. Yeah. And the point of that story is not that they were leaving the United States to avoid compliance with law. They were doing the exact opposite. Estonia had a written, comprehensive regulatory regime for digital assets, and that's what they wanted. That's why they went there, because they wanted to comply with the law. And it's really, really unfortunate. What are your thoughts on kind of the big picture, the impact on innovation in the United States?
Yeah, it's been tragic. At the same time, it's been inspiring to see how resilient crypto is and how builders are building in crypto anyway, despite this unfair environment. And crypto in that way can't be stopped. It's of high stress, and that maybe that to some extent makes it stronger. And so, I am a securities lawyer, and I love the platforms I use, the DeFi platforms especially, because I'm kind of a DeFi guy more than that's where I prefer to trade crypto, and I love the platforms. They work great, so much better than the experience with traditional brokers.
Yeah, you mentioned the pushback. I think Ripple really deserves a lot of credit for what they did in putting up the fight that they put up. Because, in my view, as a spectator, I was not involved in that case. They really pulled out all the stops and hired former directors from the Division of Enforcement to lead the charge, who knew exactly how the decision making works at the SEC and were able to push these very specific discovery requests that were granted. Very unusual. Never seen a case where that much discovery was permitted into the SEC's decision making. What was going on behind the scenes at the SEC was really remarkable, and kind of establishes a roadmap for those who come after.
Yeah.
And then with the win, last year, I believe that's been a big part of this new thing, that this new phenomenon that we're seeing of going public with, hey, just got a Wells notice. We're looking forward to fighting because we're right, they're wrong. Bring it on. That's very unusual. I don't think it would have happened if Ripple had not led the way and shown that can be done.
Don't ever underestimate the level of fight in Brad Garlinghouse. That guy is a prize fighter, and Stu Alvarado. I really admire them both. Look, I've been involved in a number of securities enforcement matters, working as expert witness for the defense, and so I've gotten to know clients who ultimately the matter settles or is dismissed, and the client says, "Look, they're bankrupting me," right?
Yeah,
Maybe that's the goal.
right.
The SEC, even if they can't win, they say, "Well, we've invested a lot in this case, so you should settle, or we'll just bankrupt you." I see that. I just worked on a case involving gold coins and silver coins. Guys were selling gold and silver coins, and they weren't lying about the amount of silver or gold in the coins. The government just didn't like that people were taking money out of their government retirement plans and going and buying gold and silver coins. So they went after them and claimed this is securities fraud and you're selling securities. Securities? They're silver coins.
Right.
They're collectibles. I mean, they just and then the government said, the SEC said, "Well, you're giving investment advice. You're an investment advisor." And they said, "What? We're telling people not to invest in securities. We're telling them to come buy gold instead." They said, "Well, that's investment advice. You're an investment advisor." It was Orwellian.
Crazy.
Yeah.
And there's plenty of examples of just forcing centralized exchanges out,
Yeah.
where they've again been accused of no fraud. There are no victims. And what's ironic to me is we are talking about crypto. There are plenty of frauds to choose from. There's really an almost unlimited supply, if we're going to be honest, of fraudulent, what they call rug pulls or whatever. Why not go after them instead of Bittrex was basically run out of the country by a 6-year investigation that they could no longer afford.
Yeah.
So anyway, not the SEC I remember from my days when I was practicing. But anyway, let's talk about what's hot right now. And Twitter is just X is just completely blowing up about what has happened in the last few days and hours. Are we seeing a turn in the politics of crypto? And so I guess kind of the first big thing to talk about is that passage of SAB 121 with Democrats on board, including the majority leader of the Senate, Schumer. What are your thoughts on what that means, what that portends for the politics?
I think it's for the best that we didn't pass any major crypto bills with the current chamber. I mean, I think what we would have gotten, for example, before SBF blew up FTX, he was pushing some crypto bills that would really kind of consolidate crypto on his exchange. It was
Right.
kind of throwing DeFi under the bus, basically, right?
Right.
For next year, the Senate will almost definitely be in Republican hands. So we're going to get something with a few moderate Democrats and the Senate Republicans, where Lummis will get to lead. Basically, in Lummis-Gillibrand's partnership, Lummis is now the senior partner rather than Gillibrand. That's for the best. It's going to make the bill better. It's going to make the bill a lot better to pass it. Because she's very much, after some of the terrible cases on the AML side, she tweeted, "Bitcoin, come and take it." I love that. I love that. So that's for the best, and we got some momentum. Look, part of the SAB 121 victory was because crypto allied with TradFi, and SIFMA was against this SAB 121 thing because it hurts them and it hurts banks. So we had some good allies that helped us, but I give a lot of credit to the blockchain. They're a young and hungry trade association, unlike most of these sleepy trade associations in DC, and they're very effective. So this is a big victory for them.
Well, yes, that's a piece that really hasn't been talked about too much. SAB 121 was not a victory of crypto over traditional finance. It was quite to the contrary. There's a reason that Chuck Schumer supported it, and that's his buddies on Wall Street. The big investment banks, the big commercial banks want in on the business. They see what BlackRock has accomplished and where that's going. And so they want to be able to provide a full menu of services to their clients, which now includes the ability to custody their crypto for them. And so it's not, I mean, I can't say it was not a surprise. I was surprised that Schumer voted for it after Elizabeth Warren's impassioned plea for how terrible it all was. But it really, it makes sense. Now the question is, what do you think, JW? Does the president sign it?
I would say, I don't know for sure, but the odds are that he doesn't veto it, that he signs it, that it goes through. I think that's likely. Liz Warren's influence is waning. And look, she's a one-trick pony. She came up yelling about we need more financial regulation. Eventually, she became kind of an ally of the largest banks because they loved the legislation that she puts forward. But she's a one-trick pony now. The world is not the same world as it was immediately after the financial crisis back in 2008. Even the national opinion after FTX wasn't as back as the blowback to the financial crisis of 2008. So she's playing an old playbook, and the game has totally changed, I think. So she's just not as effective anymore.
Well, look, it's going to be fascinating if the president signs that legislation after he sent out his veto threat a couple of hours before the House voted. And so I would love to see the White House spokesman explain this change of heart over the series of just a few days. That would be a treat. Okay.
Go ahead. It kind of means Gary Gensler's wearing a giant dunce cap around Washington, which I love too.
Well, this kind of repudiation has never happened to my knowledge. a staff accounting bulletin being overruled by the House, the Senate, and the president signs it. I don't believe, I stand to be corrected. Somebody put it in the comments, please, if this has ever happened since the SEC was founded in 1934.
Yeah, and I'll say one more thing on that, SAB 121. So I sit on an advisory committee to the FASB that creates GAAP, right? So this is the independent accounting setting body. I've talked to FASB board members, and you know what they say? They say, yeah, this was not GAAP compliant. This was over our objection. People that don't care about crypto at all just say, we care about independent accounting standards. This was some SEC people playing politics with GAAP, and we don't like that. So that's just not good for the system.
Great point. Great point. The GAO said this was not adopted legally, that it qualified as a rule that had to be put out for comment, etc. And they skipped all of that to achieve this political end, and the political end basically being that big financial institutions can't custody crypto, period, full stop. You cannot take that stuff onto your balance sheet, hold capital against it, and explain that to your shareholders. So you said something really interesting. You said you're glad that there hasn't been a comprehensive crypto regulatory, I'll put some words into your mouth, but like market structure type bill in this Congress. Can you talk to that, why you feel that way?
Well, I think it's important to eventually achieve this. I think it's important to have solutions for crypto tokens to get listed on traditional exchanges, for Coinbase to get the licenses it needs, and Kraken and all the other great actors in this space, and to allow traditional exchanges to list crypto if they want to do that. I think that's important. I also think, and to make sure we don't have a bill that throws DeFi under the bus the way that Sam Bankman-Fried was trying to do when he was pushing his version of this. And the best way to protect that, I think, is with a majority Republican Senate. And, like I said, I think it's better if Lummis is the senior partner on Lummis Gillibrand and not Gillibrand. That's better for crypto all around, better for free markets. And I think that's where we're headed towards in the next Congress. So that's a good thing.
So what we're headed to this week is a vote on this FIT 21, Financial Innovation and Technology for the 21st Century bill. Have you looked at that bill? Do you have any thoughts on any of the specifics? I hear you loud and clear. It would be better if it was in the next Congress, hopefully. But do you have any thoughts on the legislation that's kind of out there for coming up for a vote this week?
For right now, I'm not getting real vocal about it because Patrick McHenry's been good to crypto, and this is kind of his swan song. It's not going to pass the Senate. So go ahead, by all means, Patrick, pass your bill. Did great work for us, and we'll pick it back up next Congress. First of all, I'm a little worried that it doesn't sufficiently carve out DeFi, protect DeFi. Otherwise, I'm a little worried about, for example, I'm worried about DeFi protocols being told later down the road that, oh, you have to register as a DCM with the CFTC, and DeFi protocols being like, yeah, this is just smart contract code on the blockchain. There's no administrator that can file that stuff. Sorry. And then the CFTC coming in and shutting it down. Because if we can't have DeFi, then Ethereum is just trading monkey pictures. The real innovation in Ethereum to me is DeFi. And without that, no longer really interesting to me as a speculative asset because it doesn't have any underlying utility. So that's what I'm concerned about. But for now, Patrick, go ahead, pass your bill. Thanks for your help. And let's work on it again next year.
Yeah, and to be determined whether the president would sign this anyway. I am, I think, approximately where you are on this. I guess I'm at the, what's the old saying? Don't let the perfect be the enemy of the good. I think it's good in a sense. I do have a problem with decentralization being the touchstone used to determine whether an asset is a commodity or a security. That, of course, goes back way back to a memo that was prepared by some lawyers at the request of Jay Clayton, then ultimately got into a Bill Hinman speech. I disagree with that. There is no law to support that idea. I like the actual law, which says in order for an asset to be a security, an investment contract, which is what we're talking about, there has to be a contractual right to the assets, revenue, or profits of the underlying enterprise. And right now, my guess is 99% of the tokens outstanding under that standard would qualify as commodities. But if someone wanted to grant rights that traveled with the token, like for a dividend that looks like a security and should be traded as a security, it's easier to apply than, is this thing sufficiently decentralized, over time? Because it's not static. As you know, they can become more centralized, more decentralized, and then return to more centralized over time. And so I'm concerned that if you don't have a good faith regulator calling the balls and strikes on decentralization, that there's going to be a lot of confusion and a tug of war between the CFTC and the SEC, with the unfortunate project caught in the middle. But in any event, I am supporting the FIT 21. It could definitely be improved. Let's last thing, JW. The hottest topic right now at the moment is this Ethereum spot ETF. It's really an ETP, but we all call it ETF. And this surprising pivot that we're hearing rumors of, and rumors seeming to be confirmed, that it is likely that the SEC is going to approve this the first round of ETFs tomorrow or Thursday. What do you think's happening in the background, and what do you think of that?
One thing happening in the background is the SEC always knew that if they deny it, they'll be sued and they'll ultimately lose, because the precedential value of the Bitcoin ETF is just all four corners. But I think they were thinking for a while, you know what the heck, let's just have that fight anyway. They obviously don't care about the law. So that was a political calculus. Maybe that's changing. I don't know. We'll see. I hope that Ethereum ETF providers get what they need. I'm worried that there's going to be something that says, oh, that's allowed, but you're not allowed to stake, which kind of loses the point of Ethereum in a proof of stake. If you're not staking, then the value of your tokens is just going down over time, as the rest of the Ethereum inflates from staking. But we'll see. We'll see what happens. I don't think the fight's over. I think we'll have more fights to do, even after a preliminary approval of some quasi, product that can't stake or something. But I'll take any win for now, and we'll just keep fighting.
So do you think this seems to have come out of nowhere. Do you think the passage of SAB 121 with all those Democratic votes may have triggered this pivot? I don't know how Gary Gensler thinks, but it feels like someone must have told him the winds have changed here. Gary, be careful on this ETF. What do you think? What do you think triggered this?
Gary Gensler is a very political animal. Back in the 90s, in the Clinton administration, he was an undersecretary of Treasury, and he helped usher in Gramm-Leach-Bliley, which is the most deregulatory banking law in the history of the United States. And President Clinton, in his speech signing it, said, I want to thank one person in particular. Undersecretary Gensler, thank you for getting this through. So back then, he was a deregulatory guy. Then 2010 comes along, post-financial crisis. He's Mr. Regulation, and he just totally refashions himself to get back at the power table. I don't put anything past him. He knows which way the winds go, and he just shifts with them. So I think what you're saying makes a lot of sense.
Well, thank you for bringing up Gramm-Leach-Bliley. There are a lot of young people who have no idea the motivation back then it was sold as a financial privacy law to protect the information, the financial information of consumers, of American citizens. And man, has the worm turned where surveillance is the order of the day, financial surveillance of every transaction in your, whether it's your bank account or your securities account or your crypto wallet, your your custody, all of that, the government now wants in on, wants to peer into it. But back then, I'm glad you brought it up. It was absolutely bipartisan. We need to protect Americans' privacy around their financial dealings and financial information, and we need to return to that, in my opinion. Hey, JW, I'll give you the last word. I think we've exhausted our time here. This has been so much fun to be on with you and to finally meet you.
Good to see you, man. Yeah, I like your points on privacy. That's why I volunteer on the Zcash Foundation board. Love Zcash. Great talking with you, man. Let's keep watching and let's keep them honest.
Absolutely, will do. We're signing off here from the Commonwealth of Virginia for Crypto Law. Everybody have a great rest of the afternoon.
Take care, everybody. All right, good talking to you, James. I'm going to leave the studio.
See you, JW.